Yes, good morning, everyone. Can we have the appearances, please? Mr. Smith.
Yes, my Lord. Good morning. I appear with Mr. Griffiths and Mr. Joffe appeared with his junior, though I'm not entirely.
Chan, I think. Mr. Chan, is that right, Mr. Joffe?
It's Miss Chan, my Lord.
Miss Chan, oh, do forgive me. Right, Mr. Smith.
Thank you, my Lord. My Lord, I think, as your Lordship appreciates, it's agreed that subject to the committee, I can address you until 12:30, with the break that you've just indicated we shall have at 11:45. This, as you know, is an appeal from the Eastern Caribbean Court of Appeal, which dismissed an appeal from a judgment of Mr. Justice Bannister on a claim by liquidators of a BVI company against a former director whose Chinese name is written as Chen Ningning, but for convenience and without meaning any disrespect, I'll refer to as Diana, or sometimes Diana Chen.
Yes.
And the claim is for compensation for breach of fiduciary duty and/or in respect of an unfair preference concerning the early repayment in 3 tranches of a $13 million loan, which a company called Zanata had made to PFF a few months previously, the repayments being made shortly before PFF entered liquidation at a time when Diana Chen knew that PFF was insolvent and that liquidation was inevitable, and indeed shortly thereafter she agreed to start the process of liquidation in the Virgin Islands. Following the judge's dismissal of the claims, the judge was not prepared to stay the payment of any dividend to Diana by the liquidators in respect of loan debts. A parent company called or referred to as PISG, which she also owned and of which she was a sole director. So she received, following the judge's judgment, a dividend or interim dividend payment in the liquidation of some $5.4 million US. Now, as my Lord has already noted, the background is covered extensively, not just in the judgments below, but also in the statements of facts and issues and in the written cases which have been submitted. And therefore, I don't propose to say very much about it, and I'll shortly go on to the first issue. However, I would just like to say a few words about the parties and the other characters and how the case has developed in terms of developed through the courts. And I'll start with the company PFF that I've been referring to, full name Pioneer Freight Futures Company, the company in liquidation. As the committee knows, it was incorporated in March 2006 to trade in freight forward contracts, which essentially were bets on the future movement of rates in charter parties. And by 2008 had become one of the 3 largest traders in those contracts in Asia. As I've already mentioned, it was owned by PISG and therefore ultimately by Diana Chen. It never had any employees as such. It had 3 staff at the height of its operations that were employed by other companies within the group, Mr. Pan and Mr. Yao, and Yang Chen, who's been referred to as Eddie Chen, and I'll continue to refer to him as that if I may, again without disrespect. PFF ceased trading in the end of 2008 when Pan and Yao left. And that left only 2 people directly involved with PFF, Diana, who was then the sole director, and Eddie. And from that time onwards, insolvency was discussed, including with Holman, Fenwick and Willan in Hong Kong and I think in London. Diana's decision in the first part of 2009 was that PFF would try to fight to survive. And thereafter, it was Eddie's job to try to collect as much of the debts that were owed to PFF as he could, and to negotiate reductions in debts which PFF owed to its creditors. Now, Diana Chen, I can say a few words about her. In her own words, she was born in China into a family of some means and importance. I wonder whether we could just have a quick look at that. That's in her first witness statement at page 917. I think it's sufficient if I just give a reference to the bundle. So in paragraph 8 on that page, she gives some of her background, and over the page, at page 918, in paragraph 11, she says who her grandfather was, who was high up in the Communist Party in China and a minister responsible for the machinery industry. And as his granddaughter, she enjoyed vicarious respect in China. She went off to the USA to obtain an MBA. When she'd obtained that, she returned to China. Paragraph 12, decided to set up in the steel and metals industry and was very successful. And as she said in paragraph 13, her fame and her wealth grew. Ullman, Fenwick and Willan, the solicitors that were instructed in connection with the insolvency, recorded at page 458, you don't necessarily need to turn it up, that Diana was reputedly one of the richest ladies in China. And as she points out, back at page 917 that we were looking at earlier, paragraph 8, her reputation was such that she was honoured by the Hong Kong government on 2 occasions. In 2010, she became a Justice of the Peace, which is, I think, some form of political honour in Hong Kong. And then 3 years later, she received the Bohemia Star. She confirms, insofar as confirmation were needed, on page 927 in paragraph 50, that relationships and reputation are particularly important in business in China. So she had a significant reputation in China and was seemingly well known, at least in the industry in which she had been very successful. That's all I propose to say about Diana for the moment. Eddie Chen, no relation. We're told he obtained his degree, as I suppose it was then called. He then went to do a master's degree in Canada, which he completed in 2000. And then for the next 6 years, he worked in Canada. And he joined PFF in September 2007. He had no previous experience of trading freight forward agreements, but he said he soon picked up what they were all about. He didn't actually do any trading because that was the responsibility of Mr. Yao. He was involved in settlement subsequently. His 3 written witness statements are written in flawless English, and he gave his oral evidence at trial in English, which may be a factor when we look at 1 or 2 of the documents. Zonato, another BVI company, the company that lent the money in question to PFF, ultimately owned by a Mr. Song Ningning. Zonato made 2 loans to PFF. We're only concerned with the second one, which was made pursuant to a loan agreement dated the 20th of April 2009. On its face, it was for $13 million plus 9% interest for 2 years. Nothing else is known about Zonato or its assets. Mr. Song, Chinese citizen, he's said to be the ultimate owner of Zanato, and he signed the Zanato loan agreement. He's an acquaintance of Diana, or was an acquaintance of Diana Chen. There was some discussion at trial as to whether he was a personal friend or a business friend. Diana said he was just a business friend or business acquaintance, but whatever, it doesn't matter. They were previously known. He didn't give a witness statement and he didn't appear at the trial. A gentleman called Gan Xiaoqiu does feature. The judge described him as a monoglot. He's another acquaintance of Diana. Diana and Eddie contended that he was appointed a director of PFF in May 2009 when they said Diana resigned. The judge rejected that argument or suggestion in paragraph 19 of his judgment on page 26 of the record. He said Diana didn't resign then, and there's no evidence of a valid appointment of Mr. Gan. Although a witness statement was served for Mr. Gan, he wasn't called, and therefore his evidence was disregarded. So, as your Lordship has already recorded, the case is complicated in the sense that there are a number of facts to get on top of. But once one's on top of the facts, the actual arguments are not that contemplated, and the case wasn't actually overburdened with documents in comparison with other cases these days. The pleadings were relatively short. The evidence wasn't particularly extensive. It occupied about 2 or 2.5 days of the court's time. But we
one document to which I might refer, and that's page 585 of the record.
Yes.
It appears to be an email from Michelle Lung. Oh, sorry, from Shana Richards to Eunice Kwok.
Yes, sorry, I'm struggling too. Right, 21st of October 2009, yes?
Yes. And it says that they confirm that the updated register of directors has been placed in the company's file, and our records have been updated to reflect Diana as the only director of the company.
Yes.
I have to tell you that it was Lord Kitchen who drew this to our attention.
Yes.
Did that feature at all in the hearing before Mr. Justice Bannister?
Oh, yes. Yes, it did. I'm going to come on to that. It's just one confusing aspect of the case in the sense that these secretarial service people, corporate service people, seem to have been told a number of different things, seemingly by Diana or Eddie, about who the directors were at different points in time.
Well, it may be that you're going to come to this, but could I also draw your attention to the document at page 589?
Yes.
In which, in a letter from Free Court Services Limited, cancellation of the directors' resolutions of the 29th of May, approving the appointment of Mr. Song Ningning and the resignation of Diana as directors of the company. And again, I ask, did that letter feature in the evidence before Mr. Justice Bannister?
Yes. I'm going to come on to it, but since your Lordship has drawn my attention to it, can I just say one or two things in addition to what I've already said? Mr. Eddie seems, according to his evidence, which I'll show you, he seems to have mentioned at least to Mr. Song the possibility that he may become a director of the company to protect his, as it were, loan or interest in the loan that Zanato made to PFF. Now, Eddie's evidence, his written evidence, was that he never intended that Mr. Song should become a director. He just told him that he would see to it that he did become a director in order to extract the money from Zanato. Diana says in her evidence she didn't know anything about this, and she would never have agreed to Mr. Song becoming a director. And as regards these documents, two of which, and there's a series of them which I'll briefly show the committee, of course. As regards these documents, she says it's just a mistake by the corporate services people. They got the wrong end of the stick. And this never happened, and it was never intended to happen. And she said, I resigned on the 29th of May, 2009, and that was it. And I'll show the committee the submissions which learned friend Mr. Joffe made to the judge on these documents, inviting the judge to disregard them as just being hopelessly confused and evidence of nothing except confusion on the part of the corporate service agents. So that we submit was correct. That's all they show. And they certainly don't show an intention to resign by Diana at any time other than the 29th of May 2009, which the judge found, and there's been no appeal against that finding, was not implemented. Although she had originally intended to resign then, she didn't, and she carried on being involved in the affairs of PFF thereafter, as the judge pointed out.
Until August, I think, is that right?
That's right. He said until August. And we say, well, nothing happened in August. And it certainly wasn't our case that she resigned in August, nor was it Diana's case that she resigned in August. Her case has been consistent throughout that she resigned in May, a case which the judge rejected. This idea that there was a resignation towards the beginning of August is the judge has come up with, and we think he's come up with it because he made the mistake in thinking it was common ground that Diana had resigned long before the Zanato repayments were made. We say that was a mistake on his part. But I do have to show you slightly more of the documents, if I may, in due course.
Yes, certainly. Yes, of course. Now, I'm sorry to have interrupted you. I just wanted to...
Not at all. It's very helpful. And yes, I mean, obviously people have been reading the papers assiduously and found some of the more confusing aspects. And they did feature at trial, but I'll show you more about it in due course. The judge, as we point out in our written submissions, had been fairly consistent in voicing hostility to the claim of breach of fiduciary duty. We've drawn attention to some of the observations he made in paragraph 30 of our written case. Essentially, his view was that a preferential payment did not cause the company any loss. It just swapped cash for the extinction of a liability, and the company therefore didn't suffer any loss. We can see that, we don't need to turn it up, but just for the court's reference, at pages 1090 to 1091, 1719 to 1721 and 1742. And the judge didn't seem to accept that the claim was not ill-founded as a matter of law until my learned friend Mr. Joffe agreed that it was not ill-founded and agreed with the submissions which had been made to him on the law. But that really we may have coloured his approach to the facts. He certainly overlooked and made mistakes, overlooked certain important facts and made mistakes along the way, which we say reflects the fact that he didn't really like the claim at all. The Court of Appeal, of course, took almost 2.5 years to deliver their judgment, and we submit that is completely inexcusable, especially since I think both parties, and certainly we, were pressing the court and latterly the Chief Justice in correspondence for delivery of the judgment. As you will have noted from the Court of Appeal's judgment, no explanation is given for the delay, not even an apology. And whereas Malone and Fred points out, quite rightly, that the BVI was affected by some adverse weather conditions in 2017, very adverse weather conditions with Hurricane Irma and I think another hurricane, your lordships will know, the committee will know that the Eastern Caribbean Court of Appeal is a peripatetic court based in St. Lucia, not based in the Virgin Islands. In our case,
the point is made against you that while the delay was not excusable, that you've got to link the delay to any deficiency in the reasoning of the Court of Appeal.
That's right. And we accept that. That's what the authorities say. And in our submission, the mistakes which we shall point out that the Court of Appeal made can possibly, or if we have to go that far, probably be attributed to the fact that they let so much time elapse between the hearing and the delivery of the judgment.
Yes, well, you can come to
so
that.
Can I? Yes, I'll come on to that. Can I then turn to the first issue, whether Diana ceased to be a director of the company in August 2009? Before I get on to that, can I say that I know I've lost most video.
I'm sorry to hear that. You're certainly perfectly visible to us, and all the other participants are visible.
It must be a fault at my end, and I apologise for that. But I can see your lordship.
Yeah. Well, let's see if you can see someone else who will speak. Lord Briggs will speak, and then we'll see if you can see him.
I am holding up my hand.
I'm sure you are. I can't see it, I'm afraid.
Well, that is very unfortunate. But do you mind continuing so long as you can hear the members of the committee?
I don't mind at all, my lord. In fact, I recently conducted a hearing on the basis that it was just an audio hearing.
Yeah.
Hopefully things will improve as well.
If there are any difficulties, provided you can see me and hear me, do let me know, Mr. Smith, and we'll try to overcome them as best we can.
That's very kind. Thank you very much. No, I'm perfectly content to proceed as long as everybody else is. So, first question, whether she ceased to be a director in August 2009. The judge said, yes, she did. That's paragraph 25 of his judgment on page 28 of the record. Just for formality's sake, the position under the BVI Companies Law, which I'm afraid I don't think made it into the authorities bundle, is, according to section 115, subsection 1 of the Companies Law, that a director of a company may resign his office by giving written notice of his resignation to the company, and the resignation has effect from the date the notice is received by the company, or from such later date as may be specified in the notice. We also haven't got the Articles of Association of PFF in the record, but we believe they were in similar terms because of a reference on page 330 of the record. No surprises there. Director can resign by giving notice of his resignation to the company. The Act itself requires a written notice. It's possible that the articles didn't require a written notice. In this case, as we'll see, there was one letter, but that was for resignation at the end of May. Now, insofar as it may be suggested, I think it is suggested, that the committee shouldn't entertain an appeal on this point because there are concurrent findings of fact of the courts below. We submit that, well, we don't accept that submission because there hasn't been a finding by the learned judge that Diana intended to resign in August 2009, gave notice of her intention to resign in that time, and that notice was received by the company. He hasn't made a finding on any of those points. And we submit that his finding that she did resign in early August 2009 is based on no evidence at all. And if we're right about that, that on the authorities is a question of law. And we say that because of the well-known passage in Devi and Roy on page 2541, similar passage in Watt and Thomas at page 3040, and in Henderson 2745. What the judge seems to have relied on in paragraph 25 of his judgment is an absence of any evidence that Diana was involved at all in PFF's affairs, save as regards discussions about insolvency between August and November 2009. But we say the lack of evidence of involvement, if it can be relied upon, and I'll come back to that in a moment, is not evidence of resignation. If anything, it's evidence of dereliction of duty. As I've said, it was never Diana's case that she resigned in August 2009. So neither she nor Eddie nor anybody else gave evidence, whether written or oral, that she did resign in August 2009. PFF's lawyers engaged in the insolvency discussion about insolvency. Holman, Fenwick and Willan were never told that she had resigned at any time, still less August 2009. And there was some evidence before the judge, page 2213 of the record, that the partner at HFW believed that Diana remained in control of PFF until liquidation. The judge didn't think much of that evidence, but in our respectful submission, he was wrong to dismiss it. Now, submissions at trial, which I've already referred to, submissions at trial we'll look at in a moment. Submission by learned friend was that Diana resigned in May. There was no submission that she resigned in August. So if that's right, the judge has made a finding of resignation in August that he wasn't asked to make by Diana, drawn an inference he wasn't asked to draw, which he based on a lack of documentary material, which, as I say, can be explained for other reasons. If the judge were right, there surely would have been actual direct from Diana and or Eddie and or somebody else that she had resigned in August 2009. Now, I said the lack of documentation is explicable for other reasons. Eddie's evidence was that he communicated with Diana mainly by telephone or face-to-face. He said that on a number of occasions. Just for the record, we can see it on pages 939, 942 and 1043. We do have in the files, and we may look at in a moment, some email traffic between Diana and others. Not much, but there is some. But Eddie said, and the judge accepted, we say incredibly, but he accepted that Eddie ran a program on his computer which deleted all his emails after just a few days. You've probably also seen in the record and the relevant passage is at page 1206, that when Eddie presented his laptop to the liquidators, for the liquidators to examine the material on his laptop, it transpired the material had been installed on that laptop just a few days before, it previously having been wiped clean and then the material being reinstalled. Eddie said that was because there was some problem with the program, but that may explain also why relevant documentation was missing. It is very hard to believe that there were no written communications at all between anybody concerning the repayment of the Zanata loan. But that is the case. We don't have any email traffic or notes or discussions about the repayment of the Zanata loan. So we submit it wasn't safe for the judge to infer anything from the lack of documentation, and certainly not that somebody had resigned as a director. Other than that, the documentation, for whatever reason, we don't need to go into it, was not there. So, coming back to what the judge found Diana originally intended to do, which was to resign as a director at the end of May, albeit the decision wasn't implemented, and we've seen that in his judgment. The letter of resignation, I'm sure you've also seen, is at page 579 of the file. Could we just briefly look at that, please? That's in bundle 3 too, for anybody using the hard copy. 579, dated 29th of May, to the board of directors of PFF. She was the board of directors of PFF. I would like to tender my resignation as director of the company with effect from 29th of May. And then there's an inapposite board resolution, also of that date, at 575. If we can ignore the manuscript for the moment, at the top of that page, resolutions of the sole director of the company. That signature, I think it was established at trial, or said at trial, as a signature of Mr. Gann. The judge held there's never been any evidence of a valid appointment of Mr. Gann. The resolutions were that Mr. Gann be appointed, so it seems rather odd that he would be signing his own appointment, or signing the resolution appointing himself, and then the resignation of Diana with effect from 29th of May be accepted. Well, he couldn't accept that until he'd been validly appointed, and he could only be validly appointed if Diana had resolved to appoint him first. So it's an inapposite document, and at trial, my side tried to make something of the fact that the manuscript at the top said that this document was received on the 11th of November 2019. That is received by the corporate service providers. But the judge wasn't having any suggestion that the document was backdated, so that went nowhere. But it is, as I submitted, quite inapposite to effect the resignation, and the judge rejected the argument that she had resigned on the 29th of May. And that, we say, is an end of it as far as those documents are concerned. Now, coming on to the mixed messages which the agents received, to which your Lordship has already referred me. In the same bundle, slightly further on, at 588, we have the letter, which I think is one of the letters to which your lordship referred me earlier, dated 22nd October, enclosing for cancellation, which is an odd idea in the first place, a director's resolution dated 29th of May approving Mr. Song. That wasn't what we were just looking at, of course. We were looking at approving the appointment of Mr. Gan. Consent to act as director from Mr. Song. We haven't seen that. And the resignation letter from Ms. Chen, that I suppose is a reference back to the letter which we were just looking at. And these seemingly are all being returned to be cancelled, in other words, recognising that they were of no effect. So that's 588. 587 is a manuscript note. Yes, my lord.
Mr. Smith, was there any evidence about the origins and provenance of the word cancel written in manuscript across the cancellation letter on 588?
I don't recall any, my lord. As your lordship, I think, knows, I wasn't present at the trial, so that doesn't mean that whilst I'm speaking, I'm sure if anybody who was present at the trial or is more familiar than I am with that inscription will send me a message, and I'll direct your lordship's attention to the evidence.
Thanks very much.
587 is a manuscript note between, I think, people at the corporate service provider, and it's addressed to Eunice, who I presume is Eunice Kwok, who wrote the letter on 588. And it says, it's not terribly easy to read, so I'll try and interpret it for the committee. Per Angie, who I think is Angie Young at PISG, the parent company, Ms. Chen changed her mind and would like to cancel the appointment of Mr. Song as director of the company. Per Angie, she had no idea why Ms. Chen would like to cancel the said appointment. Besides, she requests us to return the original documents regarding the said appointment of her cancellation and the updated register of directors for the record. And that seems to be dated 21st of October 2009. So that seems to have been what led to the letter at 588. Some communication from Diana changing her mind about an appointment which there's no evidence was ever made anyway.
It was to return the original documents regarding the said appointment for her cancellation.
Yes, that's not what you do when you change directors. You don't need to send documents back to be cancelled. Maybe it's an unnecessary formality. But first of all, there has to be the appropriate resolutions that that's happening. And as we'll see, it was Diana's case that Mr. Song had never been appointed anyway. And this was.
May I ask, who wrote this note?
That's a very good question. I think it's somebody called Michelle, but I'm not entirely sure. I believe it's somebody at the corporate service provider who's taken who's taken the information from Diana. If your lordship would kindly go to 585, you'll see, I may be wrong, it may not be Michelle. Oh yes, there is, Michelle at the top. Michelle there is at Tricor.
Yes.
So, I think it's either the Michelle there or Machana is referred to. I can't make it out. It looks more like Michelle than Michana. But it's an internal Tricor document, I think, is the answer.
Right, thank you.
So that's 588 and 587. On please, to 594. Where on the 21st of October, in the middle of that page, you should see an email, 21st of October, from Mashana to Eunice. So probably a copy to Michelle, so all the three tree court ladies involved. Dear Eunice, thank you for confirmation of the company's corporate documents. We confirm the updated register of directors has been placed on the company's file and our records have been updated to reflect Diana as the only director of the company. So they have reinstated Diana. And in our case, they should never have changed it anyway. She should have been there throughout. 593, 3rd of November. The email at the bottom thanks Mashana for her email and says, as advised by the client, please note that the appointment to Mr. Song has been reinstated. In this connection, we attach for your record a copy of the updated register of directors. So Song was now being put back in for some reason. But then if you look on
I'm sorry, there's a manuscript note at the start. Yes. Oh, sorry, you're going to go on to that. Yes, do go on.
Go on to that. That seems to have been dated 12th November. Per Angie, the appointment to Mr. Song is made by mistake. Mr. Gan should be appointed as director of the company instead of Mr. Song. So that's 12th November. So Song was in, out, in, and then out again. In the meantime, according to them, it was Diana. And then on 12th of November, they seem to be told, oh, no, it's Gan we want as a director. What do we make of all of it? Well, in our submission, we agree with, as I'll show you, Lordship, what my learned friend submitted to his Lordship at the trial, that it's nothing other than evidence of confusion on the part of the corporate services agent and does not amount to evidence of any valid resignations or appointments.
Yes, but presumably this information is coming from somewhere. I mean, there may be confusion, but the source of the confusion is perhaps an interesting topic for discussion.
Yes.
This confusion has to be generated by some information coming to the services company.
Well, the reference to the source of the information is a reference to Angie. In both manuscript documents. And we believe is a reference to Angie Yeung. If you would kindly look at page 597, you will see an email at the top from Angie Yeung to Michelle Leung, dated the 13th of November 2009. Now, Angie Yeung was at Pioneer Metals, so another of Diana's companies. Not PFF, somewhere else in the group. I think it was a sister company. But again, Pioneer Metals, I'm right in thinking, was a company of which Diana was the sole director. And we think it highly likely that somehow or other Diana was behind these instructions to the corporate service agents. It seems odd that Angie Yeung would be giving the information, particularly as in that first manuscript document that we saw, Angie said that it was Miss Chen who had changed her mind. But she couldn't say why Miss Chen had changed her mind.
I suppose your point is that Angie Yeung would not have access to this information without being informed by someone else. And your submission is that the obvious person must be Diana.
Yes, that's right. But at the trial, Diana denied that she knew anything about any of this.
Yes.
Now, the confusion led my predecessor at the trial in his closing submissions to make some submissions on the point which were rejected by the judge. But it's important that I show you the submissions that were made. And we say they were rightly rejected by the judge, but I need to show you what my learned friend said to encourage the judge to reject them. So we start with Mr. Atherton's submissions, which are begin at page 1689 and go on to 1695. And halfway down 1689, at line 10, Mr. Atherton says she was a de jure director between 2006 when she was appointed and on or around the 14th of August. And he refers to the 14th of August because that's the date on one of the tree court documents. And he confirms that at lines 16 and 17. And at 21 to 25, he submitted that we say that the documents they were dealing with in order to change the directorship, if that's what they are doing, is August, not May. And it's the appointment of Mr. Song at that point in time. And he goes on over the page at 1690. So insofar as Miss Chen does resign, he's not accepting that she did resign, but insofar as she does resign, she's not resigning in May, she's resigning in August.
This is perhaps the source of the judge's decision that she continued until August.
Well, I think it may be the source of the judge's comment that it was common ground that she'd resigned before the Zanato repayments. But what my opponent, well, first of all, read what he's saying at the top of page 1690. He's not accepting that she did resign, but if she did resign, it was in August. See the tree court documents. But he went on to deal with the documents that we were just looking at. And at the bottom of 1692, he effectively says, this is line 21 onwards, if one is taking those documents at face value, line 21, so from the 21st of October to the 3rd of November, I'll come to that later, we say on the evidence it's also the position that Miss Chen was reinstated as a de jure director. And then he goes on to deal with, or to address the position of Mr. Gan, and he says at the bottom of page 1694, he doesn't come in until November. And then the judge says this at page 1695, and one can understand perfectly why he says it. At line 5, at 1695, it looks as though somebody was trying to produce ex post facto justification or explanation for events. That's what it looks like. And my predecessor says, lines 15 to 16, I think, my lord, one certainly maybe naively took them at first value, and the judge says, I didn't. So that was, as it what we think was an alternative case being put, that if she did resign, then the resignation was August, and in any way she got reinstated, just looking at the tree court documents on their face. However, that was rejected, and we say rightly rejected, by my learned friend. If we could turn on to page 1. Now, 1788, line 3, learned friend said, because firstly, as your lordship's already observed, I'm pausing there, I think we don't need to turn it up, I think the reference to that observation is 1458, but he summarises it, so we don't need to turn that up. The mere fact that the register of directors is changed is neither here nor there. Question is, what is the underlying position, where the resolutions, where the consents to act? There is, we say, no evidence, and there is no resolution or underlying documentation which supports the joint liquidator's suggestions here. So there is no evidence which supports the suggestion that she resigned in August, was then reinstated and then replaced. And further down that page, after referring to emails which he says Diana didn't read, between lines 16 and 18, learned friend says, "My lord, absent any suggestion that she did know," and that we submit, my lord, is that absent any suggestion that she did know what was going on, all that the emails demonstrate is frankly staff incompetence. Similarly, at the top of page 1789, the submission was the natural inference of what one's looking at here is simply mistakes being made by Angie Young. And then lines 12 to 14, so what we say is all this really comes down to is nothing more than administrative confusion and incompetence. And line 25, there simply isn't any evidence without a case. So he rejected the idea that one could place any reliance at all on what was happening at Tricor. We submit on this point he was right. The learned judge obviously felt that he was right. He didn't place any reliance on it. And Diana remained as a de jure director, and there is no evidence that she resigned in August. Now,
I think there is a distinction to be made, is there not, between placing reliance on evidence and exploring how it came into existence.
Yes, but one has to, well, first of all, the question is, did she have an intention to resign in August of 2009? We say there is no evidence of that. Secondly, if we're wrong about that, if there is evidence that she intended to resign in 2009, was that communicated to the company? Was notice given to the company? Again, no evidence of that. Thirdly, did the company accept the resignation? Strictly speaking, it may not have to, but one would expect it to if it received it. Again, there's no evidence of that. So there's no evidence that she still less that she was replaced by anybody else in August 2009. As we read, my learned friend was submitting to the judge in his closing submissions. Now, what the judge did do, and we submit he was right to do so, but he didn't carry it far enough through, is he looked at what had actually been happening and what involvement Diana had had in the affairs of PFF after the end of May 2009. And he refers to a number of emails in paragraph 20 of his judgment. Again, I don't think we need to turn them up, but for the court's, for the record, the emails are to be found in the bundle, the documents are to be found in the bundle in the following places. The advice that that Diana gave on the 14th of July is at 553. The email dated 20th of July is at 556. And the document dated 29th July 2009 is at 559. One document that His Lordship didn't refer to, but it's all of a piece. In fact, there's more than one document which preceded those emails, are documents concerning Eddie seeking approval from Diana regarding a payment that he was to make. Can I give you those references? Again, in the interest of time, I won't ask you to turn them up now. 531, 534, 535, 536, and 537. So the judge was entirely right to say that there's evidence of Diana continuing to act and staff continuing to treat her as a director in June and July of 2009. But we say the judge was wrong to draw a line at the end of July, beginning of August, when the documentary trail peters out for whatever reason, and I've already made submissions as to why one can't assume that nothing happened in that period because of the difficulties we've had with documentation. What we do have is more documentation in November and December. And could I ask you please to turn up an email on the 10th of December, which is at 6:44. Now, this is an email from Mr. Johnston at Holman's to the PFF team. I think that's the PFF team at Holman's, recounting instructions regarding the insolvency of PFF. It's a fairly lengthy email, goes on to page 646. You can see at the top of page 645 that Eddie, it's not just one email, I should have said, it's a series of emails. In the chain of emails, Eddie, on the top of page 645, writes to Diana and says, please, lawyer's advice on administration versus liquidation. Also, they give the answers to your questions. Regards, Eddie. And then Diana responds, and her email is on page 644, in the middle of the page. It's about a dozen lines or so. One of the points she's responding on is point 3, Klaveness. Now, Klaveness were one of the trade creditors of PFF, and they were bringing some legal proceedings against PFF, and those proceedings were being handled by Clyde & Co. I can't now remember whether they were in Hong Kong or England, it doesn't matter. The recommendation to Diana was that Clyde & Co seek an adjournment of the hearing was, on the grounds that you, Diana, were unable to attend the trial. If not granted, it's probably best if they appear to defend PFF rather than simply conceding the case. We would not recommend Clyde & Co mention to anyone PFF is intending to liquidate at this stage. Please confirm we have instructions to liaise with Clyde's on this basis. So an important point, and they're wanting her instructions, and they can only be in the capacity as being a director of the company in our submission. And she comes back. 3, I agreed that let Clyde & Co to seek an adjournment of the Klaveness hearing and let Holman's liaise with another counterparty. So she was still involved, not just in connection with the insolvency, but in connection with the affairs of PFF. Some time after the final repayment of the Zanato loan, which of course was towards the end of November. In our written case, paragraph 41, page 2313, again, I don't think we need to turn it up. We give other examples of Diana's involvement after August 2009, although I accept they were largely in connection with the insolvency. But that was a matter which she was interested in, we say, qua director, not qua ultimate owner of the parent company, or indeed a director of the parent company. So, in summary, the judge's conclusion that she resigned in August and that was not Diana's case, and it had no evidential foundation at all. We submit it was plainly wrong. We say it was led into error by his view that it was common ground. This is paragraph 18 of his judgment, common ground, that Diana had resigned long before the repayments to Zanato were in contemplation. That is not what was being submitted to him in the passage, which I drawn the committee's attention of my predecessor in his closing submissions. And at the very least, the liquidator's case was that Diana remained the sole director of PFF at the time of the first 2 repayments in early November, and that she was either a de jure or a de facto director at the time of the final repayment. So the judge in our submission was clearly wrong. He made a finding based on no evidence at all, we say, and that entitles the committee to intervene. The Court of Appeal, however, I must address how they dealt with the point, and they addressed it essentially in paragraphs 30 and 31 of their ruling. That's at page 46 of the bundle. They say in paragraph 30, towards the end of the paragraph, that it can be assumed that Mr. Justice Bannister viewed the evidence in its entirety and based his factual findings on that review. Well, that doesn't really address our point that there was no evidence. And in paragraph 31, they say that the judge's understanding, sorry, this is in the middle of the paragraph, 6 or 7 lines down. I am of the view that the evidence as a whole can reasonably be regarded as justifying the judge's conclusion. The judge stated his understanding of the appellant's case, evaluated the evidence, made findings of fact, and came to his conclusion. No basis to infer or suggest he did not discharge his task properly. Not of the view that any omission in his reasoning reflected a misapprehension or neglect of the evidence. None of the challenge findings can be said to be unsupported by the evidence, and the decision is one no reasonable judge could have reached. Well, in our respectful submission, that's just wrong. They were unsupported by the evidence, and this is one of those occasions where we can say that the Court of Appeal, obviously, because of the lapse of time since the hearing of the appeal, the Court of Appeal had essentially forgotten the nature of our challenge to this part of the judge's judgment.
Well, I think that's an inference, but your essential point is this, is it not? That viewed in its totality, the evidence simply did not support a finding that she resigned as a director in August 2019. That case had not been made by either party. In fact, it had been disavowed by Diana's legal representatives. And when the evidence is examined, there simply was no basis on which it could be supported. Therefore, your submission is that the Court of Appeal was obliged to examine the evidence rather than make a sweeping statement that the judge was justified in reaching it. If it concluded, which I understand that you submit it should have done, the Court of Appeal reached the conclusion that there simply was no evidence to support that finding, then the judge had reached a finding on a matter of primary fact which was unsupported, and on that account the Court of Appeal's obligation was to proceed on the basis that the judge had made a finding on which no evidence was available.
I agree. We can't say any more than that. Your Lordship puts it very succinctly and very eloquently. That's my case.
Right. Well, it's easy for me to do it while sitting here. But anyway, let's proceed then.
Yes, so the only proper conclusion was that she remained as a director of de jure of PFF throughout, and therefore she continued to owe fiduciary duties at the time of the repayments to Zonato in November 2009. So that is what we say on issue 1. Issue 2, I can deal with, I think, more shortly, because it is a much shorter point. It's a point of law. And that is whether Diana, if she wasn't a director, so if you're against me on issue 1, she nonetheless owed fiduciary duties to the company. The judge said no, and the Court of Appeal said, if we've still got it open or thereabouts in the record, paragraph 51, it was open to the judge on the evidence so to conclude. Now we say this is a pure question of law, and the facts, as far as we can see, the essential facts are not in dispute. Diana had sole signatory rights on the account from which the Zonato repayments were made, or accounts. She seemingly had delegated the operation of the account to somebody else. The judge said, I think in his judgment, that she delegated the operation of the account to PFF account staff, but there were no such people. In argument, he had said that she delegated the operation of the account to somebody at PISG, the parent company. That's at page 1701 of the record. If that's right, and it probably is right, then that person would be responsible to Diana as an employee of a company of which Diana was the sole director. It doesn't really matter who she delegated the responsibility to. The question is, if a person has sole signatory rights on another's account, does that person owe that other a fiduciary duty? And we say plainly yes, because that person cannot, without special dispensation, operate the account for his or her own benefit. They have to operate the account either on the instructions or with the authority or for the benefit of the person to whom the account belongs, in this case PFF. And we have support for that analysis in 2 decisions, which, if I may, I'll quickly refer to. And again, if I may, in the interest of time, I'll go straight to the relevant passages. So the first decision is the ultra-firm decision of Mr. Justice Lewison, as he then was, and that's at page 30. Just bear with me. Yes, beginning at page 3063, in paragraph 1285, where his lordship is discussing whether, or considering whether, somebody described as a shadow director owes fiduciary duties in the same way as a de jure director owes fiduciary duties. And his lordship says at 1285, in truth, it seems to me that the use of labels such as shadow director, which is a statutory definition, may serve only to obscure the real question. The real question is not what is the proper label to attach. It is in what circumstances will equity impose fiduciary obligations on a person with regard to property belonging to another. And then he refers to Snell and to some well-known fairly recent fiduciary duty cases. And if I may, can I ask the committee please to turn on to paragraph 1290 on page 3066, where his lordship says, this is of Mr. Fielding, who was said to be a shadow director. For example, in the present case, it is common ground that Mr. Fielding became the sole signatory on Sequest's bank account. It is, in my judgment, indisputable that as sole signatory on that account, he was not entitled to draw on the account for his own personal benefit. By voluntarily becoming the sole signatory on that account, he took it upon himself to assume control of an asset belonging to another. That voluntary assumption must, in my judgment, carry with it a duty to use the asset for the benefit of the person to whom it belongs. That duty is properly called a fiduciary duty. So perhaps no surprises in our respectful submission.
I beg your pardon, Mr. May I just interrupt you for a second?
Of course.
I rather understood the case for the respondent to be that the issue of this account and the signatory to it is a bit of a sideshow, because in fact the business was always conducted electronically.
Yes. I agree. That doesn't mean we disagree that it's a sideshow, but you're right. Your Lordship is right. That's I think the gist of their submission. We submit that starting from first principles, if somebody in the position of Diana assumes she's not a director of the company, is the sole signatory on the company's bank account, then we submit on this learning she owes fiduciary duties to the company to ensure that the company's assets aren't misapplied. Now, she seemingly delegated the operation of the account to a third party. And one way or another, we say the monies were misapplied because they were used to repay the Zonato loan. We say that was a breach of the fiduciary duty which she owed to the company. That happened because she didn't prevent it happening. She didn't stop it. She didn't supervise the operation of the account, or if she did, and the judge found that she probably did know that the monies were going to be repaid, but did nothing about it, that was a breach of fiduciary duty. Now, the point that's put against me on that aspect of our argument.
Mr. Smith, you may not be able to see me. I don't know if you can.
I can.
You're putting the duty rather higher than Mr. Justice Lewison does in paragraph 1290 of Ultraframe, aren't you? Because he says that the only duty which inevitably flows from being the sole signatory on a company's account is not to use it for your own benefit. But he emphasizes that doesn't mean that the full panoply of fiduciary duties, which might affect, say, a sole trustee of a trust fund, or a director, thereby fall on the account, on the person with the signing authority. And I know you're going to go on and say, well, she did actually, all these payments were made for her benefit, but at the moment you're suggesting that once you tick the fiduciary duty box, then she has duties to supervise the account and make sure that it's not used in any inappropriate way, regardless of whether a payment is or isn't for her own benefit.
Yes, that is my submission, my lord, and it may be, as your lordship points out, that I am going slightly further than Mr. Justice Lewison recognised.
You do seem to be.
No, well, I accept that, my lord, but nonetheless, in our respectful submission, it must be right that if a person is a fiduciary as regards an account which holds somebody else's money, then if that person delegates the operation of the account to somebody else, that must imply, or it must mean as a matter of law, that there should be some supervision over the operation of the account to ensure that the monies are being used for a proper purpose.
I don't think Mr. Justice Lewison was setting out all the fiduciary duties that flow from the position mentioned at paragraph 1290. But could I just ask a follow-on question? Why is it that we know so little about the payments to Zonato? Surely it is possible to trace the payment instructions and from whose computer they were given, and whether there was any confirmation of the instructions, who had the password, and so on.
Well, your ladyship may well think that we ought to know that, but unless I've missed something, we don't. It's possible that we don't know it, not just because of the difficulties the liquidators have had in obtaining documentation in the liquidation, but because the account was actually operated by someone at a different company, not PFF, but as I submitted earlier, PISG. And PISG has not been obliged to give any disclosure in the proceedings. If I miss something, somebody will let me know and I'll bring it to the committee's attention. But whilst
it might be a good moment then for us to take a break for about 5 minutes or so.
yes,
And perhaps we can therefore.
I was just going to round off on this point that if we're wrong on the de jure directorship point, then we are in our submission right that Diana owed fiduciary duties as the sole signatory on the account.
Well, it may give you the opportunity to seek further information about that. I rather gather, without putting you under any pressure at all, Mr. Smith, that you are coming to the end of your submissions.
Well, I've got two issues now to deal with. One is causing or procuring the repayment and the pleading point that Loan Friend takes. And the other is the entirely separate, well, not entirely separate question, but the separate question of liability under the statutory provisions for unfair performance.
Yes, of course. Yes, of course.
So I think I probably will, subject to the committee, need the whole of my time to deal with those two.
Well, that's perfectly all right. Right, we'll resume again in about 5 minutes or so. Okay, thank you. Now, Mr. Smith.
Yes.
Can you see us now?
Yes, I can see you all at the moment.
Oh, that's splendid. Well done.
I think it's the vagaries of the broadband in the countryside mean that it goes in and out. But I've always been able to see you, my lord. It just
well, you can't be in any deeper countryside than I occupy at the moment. Right. Let's
yes. The answer to your question, we haven't got an answer, I'm afraid. No documents showing the instructions to pay to make those payments were disclosed, and the liquidators have not found the instructions or been able to get hold of them during the liquidation. So the answer may well be, as I speculated, that that's because the instructions were given by somebody in another company, and Diana had set them up to be able to give them. Anyway, if I get any further information over the course of the short adjournment, I'll pass that on when I come to make my reply submissions.
Thank you.
People will be continuing to look. So just looking at the statement of issues that I have to address at page 2191, that was all I was proposing to say by way of opening on issues A and B. So I now turn to issue C, which refers to the judge's ruling in paragraph 29 that there is no evidence at all that Diana caused or procured the repayment of the Zanata loan. Now, the reason why he used that phrase is because that is the phrase that's used in the amended statement of claim. So that was how the case was pleaded against Diana, that she caused or procured PFF to make the payments. But it's important to note two things. First of all, there are two words there, causing and or procuring. And secondly, that what those words mean is to be taken from the statement of claim itself. And in that regard, could I draw attention, please, to paragraph 13, subparagraph 1 of the amended statement of claim on page 117 of the bundle, where it is pleaded that notwithstanding her purported resignation on the 29th of May, from that date until after the appointment of the JPLs on the 17th of December, Ms. Chen was the sole authorised signatory on the mandate and was referred to as director on the records for the company held with Bank of America. She was therefore responsible for authorising and causing and or procuring all payments made from this account on behalf of PFF during the period, a total of 65 transactions with a total value of $52 million US, which included each of the Zonato payments. So she was responsible for authorising and causing and or procuring because she was the authorised signatory on the mandate for the main trading account. Now, you may say to me that the use of the word procuring in that context is a bit of a stretch. You procure a payment just by being a signatory on an account. But whether or not that's right, there is also the word causing. And in our submission, she did cause the payments to be made by delegating the ability to make the payments to somebody else. She put them in the position to be able to make the payments. And especially is that so when one looks at the finding that the judge made in paragraph 28 of his judgment at the very end, on page 29 of the record. I think that the probability is that she knew of and did not object to the repayment. So he found that she knew of it. He found that she didn't object. She was the sole signatory on the account and could have stopped it. But she didn't. And that in our submission, on the way that this pleading is drafted, established that she caused and or procured the repayment. So to the extent that the judge rejected the, sorry, my lord.
Can I just understand what you mean by delegating? There are two pictures going through my mind. One is a general delegation where the sole signatory simply says, you can take payment instructions from the account staff at company X, one of the other group companies or the parent company, and then says to the account staff, you take your instructions as to what payments actually to make for this company from the person in authority in this company. Let's suppose purely, for example, Eddie. So that the instruction goes Eddie to account staff in associated company to bank. That's one kind of delegation. The other kind of delegation is she decides that a particular payment is going to be made and delegates somebody in her parent company's account staff to authorize the bank to make it. I think you're talking about the first of those two pictures, aren't you?
I am, because there's no evidence. We had no evidence of the second. Yeah. If the second one does fit the word procuring better, because it's looking at a particular payment and saying, go ahead and make this payment. But the evidence before the judge was of a more general delegation to operate the account. But he found that she probably did the payment was going to be made and didn't object to it.
But I mean, I find the first of those types of delegation not to lie comfortably with the notion that Diana, as the delegator, caused or procured any particular payment. If, as the sole signatory, she just set up a structure whereby the companies, somebody in the company like Eddie, arranges for payments to be made through accounting staff who she nominates for that purpose.
Well, the pleading, Lord, is that she caused all the payments by setting up that structure.
Well, I know, but if the picture you're presenting is it was simply a general delegation rather than something done separately in relation to each payment, I have some difficulty in thinking why a general delegation of that kind means that the person with sole signing rights causes or procures the making of any particular payment, even if they know about it.
Well, the payment wouldn't be made without the delegation, would it? It's a sort of sine qua non, I suppose is how I put it.
Thank you.
But I can't take it any further than that. But that's how this pleading has to be understood. When the phrase cause or procure is being referred to, it is alleged that she caused and or procured all the payments from the account because she was the signatory. So the judge and the Court of Appeal in our submission read too much into the idea that Diana caused, or into the phrase causing or procuring the repayment, and omitted to consider how the point had actually been pleaded on page 117. And we refer in our written case to the decision of Mr. Justice Patton, I think it was, in the interest of time, I don't think we need to turn it up. It's page 2723, where His Lordship said that it was a breach of duty for a fiduciary to sit in silence and allow a payment to be made that was not in the company's best interests. And the transfers here, we submit, were clearly not in the best interests of the company because they were not in the best interests of the creditors as a whole. Insolvency at that time, or some liquidation procedure, or at the very least administration, being inevitable. They were just in the interests of one creditor, that was Zonato. And that is a, or may amount to a breach of fiduciary duty, is established in the authorities which we refer to in our written case and which are in the bundle. But since there was no dispute in the tribunals below on those points of law, can I leave them for reply in case I have to address them at all? The starting point, I think, is the decision in the West Mercia case. Yes. Now, just to round off on the position of PFF at the time the repayments were made, again, for the committee's note, the available funds of PFF at the time the payments were made were almost exhausted. And we can see that from Mr. Byers' first witness statement, paragraph 456, which is 874 and 875 of the record. And again, for completeness, it wasn't as though steps hadn't already been taken to protect Zonato, because Zonato had apparently already received the assignment of the benefit of certain PFF's contracts at the end of October. Eddie tells us paragraph 20, subparagraph 10 of his second witness statement. Again, I don't think we need to, but I'm afraid I forgot to note the page reference. I'll get that for you in due course. It's Eddie 2, paragraph 22, which is in bundle 4 somewhere. And again, in our written submissions, we point out that it's not the law that a company director can simply delegate his responsibilities without supervision. We rely on an observation of my Lord, Lord Briggs, or Mr. Justice Briggs, I think as he was, Lexi Holdings, paragraph 219, that's page 2839 of the bundle, and an observation of the Court of Appeal in Neville and Krikorian, paragraph 52 at page 2873 of the bundle. So we say that Diana was in breach of fiduciary duty by causing, whether through delegation without supervision and or not intervening to stop, the transfers which were not in the best interests of PFF, even if she didn't herself directly procure those transfers. And the judge and the Court of Appeal therefore erred in finding that she hadn't acted in breach of fiduciary duty. However, we go on, as the committee knows, to say that there is evidence, and evidence which was wrongly rejected by the judge, that shows that Diana did indeed procure the repayment of the Zanato loan. And this turns on a meeting which the then joint provisional liquidators and 2 members of Grant Thornton's staff had with Eddie in Beijing early in 2010, 28th of January 2010. So you have the repayments in November 2009, the provisional liquidation commencing on the 17th of December 2009, investigations commencing, and then a meeting with Eddie in Beijing, 28th of January 2010, roughly 8 weeks or so after the final payment to Zanato, when one would assume the repayments would have been relatively fresh in Eddie's mind. Now, the note that is relied upon is at page 751, and because of its importance, I would just like to turn it up briefly. So 751 is where the note begins, and you can see who was present. And the relevant text is at page 754 under the heading Borrowings. The beginning of the discussion about 2 larger loans from companies called Harwich Gain and Rich Concept. We don't really need to focus on those. The judge seemed to accept, at least in argument, that they were, I think he described them as Diana's companies, but companies that she controlled or was otherwise interested in. And they were, as Eddie described in paragraph 4 of this note, friends of the company, or as Eddie is recorded as describing they provided their loans in August and September 2008. And then the note records in the final 3 paragraphs that Eddie advised that the loan from Zanato was fully repaid by a few payments between September and December. It was 3 payments in November. The Zanato payment was queried by the liquidators, and Eddie advised that he does not know any further details, and that anything in relation to this payment and this funding was arranged by the parent company. I've been calling it PISG. Eddie advised that Diana tried to pay back as much of the loans made to the company as possible because she is reliant on her reputation. Eddie and Diana is aware that companies such as Harwich Gain and Rich Concept are only willing to make loans of 100 million without any security because of Diana's personal connections. Well, that doesn't seem to be the whole story, but we don't need to be concerned about that. So it's really the sentence that Eddie advised that Diana tried to pay back as much of the loans made to the company as possible because she's reliant on her reputation. And the only loans that were repaid were the Zanato, was the Zanato loan and part of the Harwich Gain loan. So when he referred, as he's recorded as referring to loans in the plural, he must have been referring to the Zanato loan as well as the Harwich Gain loan. Now, we submit it's inconceivable that the note takers would have misunderstood what Eddie was telling them. And in this context, it's important to note what Eddie said in cross-examination about the questions that were being put to him. So could we turn up, please, pages 1515 to 1517 of the record. So at 1515, between lines 13 and 17, he says, so as I just said, it was the context. The full question was to give more details. Tell me about the Zanato loans, right? How it was negotiated, how it was rearranged, and how it was repaid it. So this was the context. and he took a point about the use of the word payment in the note, which he said he wouldn't have used. That's on page 1516. He said he would have used the word repayment if he was intending to refer to the repayment. Then at 1517, line 11, he was asked, you were asked about the repayment and their reference is made to the payment. You're asked about repayments. It's recorded, you say you don't know anything about it. Well, I don't want to repeat it, he says. You don't, I just think, don't you think it really strange if the liquidator jumps to the repayment without asking the details how this loan arranged negotiate? This is just common sense. They asked about this loan for the whole process, and not just the original arrangement of the loan, but also the repayment of it. So that was the context in which the questions were asked. He didn't seem to be in any doubt about that, and those were the answers that he was recorded as giving, and he squarely pointed the finger at Diana wanting to repay the loans. And that, we submit, was good evidence to support the claim of procurement by Diana of the repayment. And sorry, I should, in that context, also have gone on to page 1519, where he said between the lines 14 and 18, PF didn't serve the liquidation. I think that means initiate the liquidation. And in that conversation has said, Diana wants to pay back the loans, wants to realise the values and wants to pay their creditors right. So that was very natural. So again, another reference to Diana wanting to repay the loans. That explanation, sorry, before I get on to that, going back to the note, page 754, he's recorded in the final paragraph as advising that Diana tried to pay back as much of the loans made to the company as possible because she's reliant on her reputation. And that has a ring of truth, having regard to what Diana said about the reputation in her first witness statement, which is what I pointed out first thing when we started today. She was a woman of considerable substance in the PRC and Hong Kong, and she was destined to be by the government in Hong Kong and subsequently in 2013. Now, I'm going to, in the interest of time, I'm going to have to take this more swiftly than I was planning to, but there was written evidence on how this note came to be prepared in these terms on both sides. And if I may, and I'm sorry to have to do this, but in the interest of time, I really don't have much choice. I'll just give you the references to the written evidence. Byers 1, at paragraphs 35 and 53. Now that's page 873 of the bundle. I suspect that's just 53. Sorry, I haven't got a reference to the other one. I'll try and find it. Charters 1, he was the associate of Grant Thornton at the meeting. Paragraph 9, page 884. Eddie 1, paras 83 to 87, 959 to 60, and 98 to 102. That's paras 98 to 102. That's pages 964 to 5. Byers 2, paras 31 to 35. That's 900 to 901. And Eddie 4, paras 5 to 14, pages 1028 to 1033 of the bundle. And then there was cross-examination. Now, could I just draw attention to that, please? So, first of all, Mr.
Just before you do, paragraph 35 is at page 868.
I'm very much obliged. Thank you. Yes. So, Byers' cross-examination 1201 of the bundle. So he was one of the then joint provisional liquidators present at the meeting. And it was put to him at the bottom of page 1200. You really aren't in a position to assert the note is accurate where Eddie says it's wrong, are you? Well, I think I can't, because the meeting happened so long ago. I can't necessarily independently, with reference to this document, remember every single point. That's absolutely correct. But further down at 5, and I think there was, in relation to the contentious points around what was said about Zonato, I believe, and the payments to Zonato, I believe that what we have in the notice is correct. That must mean no. I think that must be a typographical error. And on the next page, 1202, it was put to him at line 10. What's clear is what's being asked about there is the payment of the loan in the first place, not the repayment. And he said, well, I don't think I would ever use the word payment to actually refer to the advance of a loan. And then Eddie's semantic distinction between payment and repayment is put to him, and he rejects that. At the top of page 1203. And then at the bottom of 1203, when it's put to him, you don't recall Eddie using these words, do you? He says, I recollect some of those words being used. Whether they were constructing exactly that sentence, clearly I think it'd be wrong for me to say I remember that precisely. I certainly recognise those words and believe that that's the substance of what was said. So there wasn't, unless I've missed it, a direct suggestion that the note was mistaken, but that was the thrust of the questions. However, when Mr. Charters came to be examined, and he was responsible for overseeing the production of the note with the other assistant, 1234 to 1236, he explains, first of all, who prepared, and then on 1235, he's asked at line 18, it's fair to say that these notes are not a verbatim transcript of what was said. That's correct. And in fact, they contain a summary of what was said, don't they? They do. And you said that you approved it. When did you do that? And he says it would have been early February. And he can't remember whether he approved them from memory or from her notes. But it's put to him that they contain a summary of what was said. He agrees. And that's what they do. It's not put to him that the note is mistaken in what it records that Eddie said. So there was the note. The official the JPL's then joint official liquidators testified it was accurate, and it wasn't put to them, the witnesses, that it was inaccurate. The judge, however, dismissed this part of the case rather peremptorily. In paragraph 23 of his judgment. At page 27 of the record, he says, liquidators attempt to rely on certain statements supposed to be made by Chen at the meeting in January. All that the court has is a summary note of the meeting. Well, that's not right. He had the evidence that was given orally as well, and the written evidence, demonstrably inaccurate in at least one respect. It referred to US dollars in one point rather than Hong Kong dollars. That's the point that's being made in a different part of the note. It does not set out any of the questions to which Mr. Chen's alleged statements are supposed to be responsive. Well, attendance notes don't usually do that, certainly not in my experience. It's not a transcript. It doesn't purport to be. And despite Mr. Chen's being assured he would be permitted to review and comment on its contents, he's never done that. Well, that's true, and Mr. Byers, and it was an oversight, but that doesn't mean that the note is inaccurate. And then he says, as evidence of the circumstances surrounding or the motivation for the repayment of the loan, it is thus, for those reasons, of no assistance. And attempts by the liquidators to extract meaning which suited their case from ambiguous or non-committal responses, we submit they weren't, by Mr. Chen demonstrated only the folly of treating this material as having any probative value. So he didn't like the note, and he didn't like the conclusions that he was asked to draw from the note, but he omitted all the written and oral evidence from his consideration. And with respect, he was wrong to do that. He was certainly wrong to dismiss the note as being of no assistance. And in that regard, we say the judge clearly failed to take advantage of seeing and hearing the witnesses. They gave evidence on this point. He doesn't refer to it. So going back then to the paragraph where I started on this topic, where the judge said there was no evidence at all that Diana caused or procured the repayment, the judge was wrong. There was evidence that Diana procured the repayment because the liquidator said Eddie had told them that she did it to protect her reputation. She wanted the loans repaid to protect her reputation. Now, the Court of Appeal's ruling on this point is, we say, at least equally wrong. So, if we go, please, in bundle 1 to page 63. In paragraph 74, in the first couple of sentences, they recount the judge's ruling, and they say that he followed the correct approach in assessing the note, well, with respect to the written and oral evidence. He had to decide on the reliability and weight of the note and the circumstances in which it was made, true. He fully reasoned why he came to the conclusion that the note was of no assistance and lacked probative value, but those reasons in our respectful submission don't stack up. In short, he didn't find the note helpful because in part it did not contain the questions and it had never been shown to him. So that's only 2 reasons the judge gave, but they're not satisfactory. He would have paid, then this sentence, he would have paid due regard to all the evidence inclusive of the note and the overall probabilities. Well, that, with respect, is bizarre, because he said he didn't pay any regard to the note because he found it of no probative value. The Court of Appeal say he would have paid regard to it, along with everything else. Was he wrong? Although the appellant sought to criticise some aspects of his reasoning, the conclusion he arrived at was one which was open to him. Well, with respect, it wasn't. The Court of Appeal haven't properly analysed the points that we made to them in connection with the note. In paragraph 75, they say further, this is about 4 lines down, I agree with Ms. Chen that the evidence of Messrs. Charters and Byers merely goes back to and stems from the note itself as opposed to other evidence. Well, with respect, that's not a fair reading of the evidence they gave in cross-examination. So the Court of Appeal ruling is no better, and for those reasons, in our respectful submission, the decisions of the judge on this point are plainly and seriously flawed. There's another point that I've overlooked. Paragraph 92 of our written case, where we refer to the judge's assertion that it was common ground that Eddie was the person who directly caused the repayments to be made. That was not common ground. The judge was wrong to say it was common ground, and the Court of Appeal overlooked that complaint as well. So is the committee free to intervene? Yes, in our respectful submission. See Devi and Roy. Proper judicial procedure requires all admissible evidence on critical points to be weighed, having properly understood the case being made. And the authority for that is the Conti Corp decision at paragraph 8, which is at page 2422 of the bundle. We also rely on paragraph 164 of Conti Corp on page 2489. So if we're right so far, and Diana did cause or procure the repayments, then she's liable to restore the payments to the company for breach of fiduciary duty, based on the authorities to which I referred earlier, and West Mercia and the later authorities, which are referred to in our written case. So I now turn to the fourth issue, and I've only left myself a few minutes, sadly, to address that. It's a very interesting issue under section 249 of the BVI insolvency law, because it also has ramifications for UK insolvency law. The judge refused to consider the unfair preference claim, saying that it added nothing to the claim for breach of fiduciary duty. With respect, he was wrong about that. For the unfair preference claim, for instance, one didn't have to establish that Diana owed any fiduciary duties. The Court of Appeal took a different course. I think they must have realised, but they don't say, that the judge hadn't given that claim consideration. And they found that on page 73 of Bundle 1, the criteria which have to be satisfied before the court can exercise a discretion under section 249 of the BVI insolvency law were satisfied. In other words, that the payments to Zonato were made when PFF was insolvent. They were made within 6 months of the commencement of the liquidation, and they put Zonato in a better position than if Zonato had had to wait for a dividend in the liquidation. And the Court of Appeal also found at paragraph 105 that the Zonato repayments were not made in the ordinary course of business of PFF, and none of these findings is challenged unsurprisingly. Thus, the Court of Appeal found that an unfair preference was established, but having established that they had jurisdiction to make an order against Diana, even though she was a third party, they decided against exercising that jurisdiction, and they gave 2 reasons in paragraph 111 and 112 on page 77. And 111, first reason, having referred to a case called Oxford Pharmaceuticals, which I'll touch on briefly in a second. They say in the middle of that paragraph, the starting point for the court's consideration is whether an order against Ms. Chen is required for restoring PFF's position to what it would have been in if it had not entered into the transaction with Zonato. That is the question. But they say, finding that at the time PFF repaid the Zonato loan, insolvent liquidation was inevitable. The fact is that PFF was insolvent. That doesn't answer the question. It's not a question of whether you can turn the clock back and make PFF solvent again. It's a question of whether the PFS estate can be restored other than by making an order for repayment, or for payment, I should say, against Diana. So they've misunderstood the jurisdiction. 112, they talk about the absence of a benefit, not necessarily precluding an order pursuant to section 249, but it being a factor that the court can take into account in the exercise of its discretion. There was no evidence of any actual benefit other than a reputational benefit. And they say, insofar as a reputational benefit is concerned, the Zonato payment was minuscule compared to the $187 million PFF owed. Well, pausing there, PFF owed that amount or something similar on loans, most of which were to Diana's own companies, or companies she controlled. So most of it were from loans from companies which she controlled. That's Rich Concept and Harwich Gain. The only third-party loan was from Zonato. And you can't weigh the reputational benefit against the amount of the outstanding under the loans, because the reputational benefit is something quite different. The question is whether a reputational benefit is a benefit which the court can take into account when exercising a discretion under section 249. They don't really answer that question. They say it was minuscule, so we're going to ignore it, not the principle. So we say they're wrong. Yes, my lord.
to Diana. I'm so sorry. Did you plead benefit to Diana as a reason why an order should be made against her? And your main case was based on breach of fiduciary duty.
Yes, but there was a plea that she gained a reputation from the loan.
If you could just give, you don't need to take me to it, but if you could give me the reference at some stage, that would be useful. I know you're under time pressure.
If someone can give it to me, then I'll.
Yes, that's fine.
You mentioned it in your reply. Don't take time over it now.
No.
Yeah, okay, thank you. There are, however, other points that the committee must consider in this context. There's the decision of 2 deputy judges in the Oxford Pharmaceuticals case, which is referred to in our skeleton, in our written case, and also the one in Johnson and Arden. And essentially, what they say is that in order for a benefit to be taken into account when assessing whether or not the discretion should be exercised, the benefit has to be capable of quantification in monetary terms. If it can't be quantified in monetary terms, then the court shouldn't exercise the discretion. Now, with that in particular is what one takes from the Oxford Pharmaceuticals case, and it's page 2968 in the bundle. And we respectfully submit, with the greatest respect to the learned deputy judge, that that is not right. It's wrong to put that constraint on a broad discretion, such as is conferred by section 249. And in the other case I referred to, Johnson and Arden, the learned deputy judge there said that the exercise under the equivalent of section 249 was restitutionary, not compensatory. In the bundle, the relevant passage is 2797 to 279. And with respect, we say again, that's correct. The question the court has to ask is whether an order is necessary to restore the company's position to what it was before the payments. It doesn't mean that a payment that a third party can't be made to make a payment which in some way restores the position or the estate of the company. So we say the judge was wrong not to give this claim.
Sorry, Mr. Smith.
Yeah.
Have you looked at the recent decision of the board in Scandinaviska on the nature of the power to make payments in a preference situation? I merely mention it because there is a quite lengthy consideration of the restitutionary aspects of that jurisdiction.
Well, it sounds, I haven't.
Although not on the point about whether you have to measure the benefit in monetary terms.
It sounds, my lord, I'm very grateful for that. I know others in my team have looked at it. It sounds as though I haven't given proper consideration to it, and I'm going to eat my sandwich in half an hour by looking at it. And so I'm grateful for the tip.
It may be of no help, but I thought you at least ought to think about it in relation to your submission that the jurisdiction is not essentially restitution.
Yes, that is my submission.
Yeah.
So
you're going to be eating a sandwich in something less than half an hour, Mr. Smith.
yes,
So I have to ask you to wind up now, please.
Winding up, we say the question hasn't been exercised in this case. It should be exercised to make Diana repay the amounts paid to Zanato with interest because she caused or procured payments, or because she knew the payments were to be made but failed to them, because she perceived there would be some reputational advantage to her in Zanato being repaid prematurely, and because she's a high net worth individual, and the reference to that is 1427, and has never contended that the payment or making a payment would cause her undue hardship. In the appendix to our written case at page 2235, we set out the relief which we seek if the appeal is allowed. If I may, I'll deal with that either later today or in due course in the interest of time. I think it makes sense reading it through.
Thank you very much indeed.
Unless I can help the committee further, those are my submissions in it.
Thank you very much indeed, Mr. Smith. Does Mr. Griffiths wish to follow?
I'm not sure he's got his microphone on.
You know what? Well, we'll assume that he doesn't wish to follow, and I'll invite Mr. Joffrey to begin his submission then.
I'm going to start, if I may, with that latter ground, the ground relating to the Insolvency Act claim, before going back to the fiduciary duty aspects of the case. And our first submission is that the court's power under Section 249 of the BVI Insolvency Act is a restitutionary, not a compensatory provision. The provision itself is at Section 2491B, which is on page 2302 of the bundle. And one sees that it is in part 8, which is one which deals with voidable transactions, and that starts at page 2297. Now, if one looks at the language of it, it simply says the court may make such order as it considers fit for restoring the position to what it would have been if the company hadn't entered into the transaction. And so we submit that just looking at those words, it's indicative of the fact there's a restitutionary provision. And indeed, we say that that provision is backed up by Section 2492, which commences on page 2302. Now, I'm not going to, in the interest of time, take the committee through the provisions in Section 2492, and that they are without prejudice to 2491B. But if compensatory orders were contemplated by Section 249, you would expect something so obvious to be expressly catered for in Section 2492. But when one looks at the list, there's no reference there to compensatory orders at all. And it's true that Section 249(2)D provides for orders requiring respondents to make payments to the liquidator, but that is a payment in respect of benefits received by him from the company, which would indicate that, again, it's not a compensatory order, but restitution for a benefit which has actually been received. We would submit that the benefit has to be quantified in financial terms, because if that weren't the case, the amount of the payment to be made under Section 2492D couldn't be calculated. And we would submit that any liability of a respondent under subsection D is plainly to be measured by the benefits received, not by the company's loss, because it says so, and because if it was measured by the company's loss, that would be a compensatory provision. Stepping back for a moment, if compensatory orders could be made under Section 249, the only persons against whom such an order might be made would be officers of the company who were guilty of misfeasance or breach of fiduciary duty in relation to the unfair prejudice, because obviously non-officers don't owe any such duties. And in that respect, we'd like to draw attention to the wholly separate provisions of Section 254. Now, that's actually in the supplemental bundle, but it would follow on from page 2304 in the main bundle. And you'll see at the bottom of 2304 that that's in a separate section, separate part rather, part 9, malpractice. And Section 254, if I can just ask the committee just to look at it briefly in the supplemental bundle at pages 3 to 4. That one sees Section 2541B, order can be made against somebody guilty of misfeasance or breach of fiduciary duty. 2542, orders can be made against people who are or have been officers of the company. And 2543B, an order can be made for payment of compensation for the misfeasance or breach of duty. And 2544, we see procedural safeguards about giving the opportunity give evidence, call witnesses, bring other evidence, etc. And what we submit is that Section 254 in a different part of the 2003 Act provides a specific remedy for directors' breaches of fiduciary duty. And there's no need for Section 249 to provide a duplicative remedy or to read a duplicative remedy into Section 249. Indeed, Section 2544 provides for specific procedural safeguards for respondents, and it would be odd if those safeguards could be circumvented by an application under Section 249. So our submission is that compensatory orders are dealt with by Section 254, not Section 2491. Indeed, if it were otherwise, a liquidator would never need to bring an application under Section 254 if he could bring one under Section 249. He could simply apply under Section 249. And indeed, in this case, the committee will have noted that in the amended statement of claim, the liquidators applied under Section 254. They didn't merely apply under Section 249. Now, as my friend indicated, the conclusion that this is a restitutory provision was reached in the two English cases of Oxford Pharmaceuticals and Johnson and Arden. And there is indeed a close correlation between the provisions of the Insolvency Act 2003 and the English Insolvency Act 1986, which we see at page 2306 of the bundle. And it is sections 245 and 249 of the Insolvency Act 2003, which are at pages 2299 and 2302 to 2303, are very similar to the Insolvency Act 1986, sections 2393 and 4, which are 2307, 2308, and 2411 and 2, which are at 2310 to 2311. And whatever the precedental value of the two English cases, we submit the conclusions on the language of the Insolvency Act 1986 are correct. There's no prior BVI authority which discusses the legal issues raised in the present case, but we submit the two English cases correctly reflect the position under BVI law. Second submission we want to make is that the position to be restored under Section 249 is the position of both parties. The wording used by Section 2491 is restoring the position, not restoring the company's position. Now, restoring the position per se requires restoration on both sides, not merely on the company's side. And to restore only the company wouldn't be restoring the position, it would be creating a new position. And that's a point that was considered in Johnson and Arden at paragraph 92, page 2797, where the deputy judge held that it wasn't limited to restoring the position of the company, but to putting all the parties back into the position they would have been in had the transaction not been entered into or the preference given. And again, we would submit that is the correct conclusion, applicable also to Section 2491. Third short submission we want to make is covered in our written case, but I just mention it for completeness. Section 2491B creates a discretionary power and on the authority of Paramount Airways, cited in Oxford Pharmaceuticals. It's not obligatory for the court to make an order. It can, in its discretion, decide to make no order. Our fourth submission is that an order can only be made against a party. The discretion can only be exercised under Section 249 against a party who has received benefits. And we say that the discretion only applies where the party concerned is in a position to restore by having been in the chain of receipt of assets involved in the voidable transaction or having obtained tangible benefits derived from those assets. In other words, as a matter of discretion, the court won't make an order against a third party unless the order was required as part of the restitutionary process. And the third party has something of monetary value which can be restored to the company as part of that process. That would mean either assets forming the subject matter of the preference or some benefit in monetary terms acquired by him. At the very least, we submit the absence of receipt of assets or benefit is a very powerful point to take into account in the exercise of the discretion. Indeed, again, both Oxford and Johnson and Arden conclude that an order can only be made against a party in the chain of receipts involved in the voidable transaction or having obtained tangible benefits from the assets. Like my learned friend, I won't go to the cases, but I'll just give you the references. It's Oxford Pharmaceuticals, it's page 2968, paragraphs 84 and 85. And Johnson and Arden, page 2798. I'm going to ask the committee to eventually to look at the whole section from paragraphs 94 to 101, but in this connection, in particular, paragraph 99 and paragraph 101. And our invitation to the committee is to conclude that under section 249, the court can only properly exercise its discretion against a party in the chain of receipt of the assets involved in the voidable transaction or having obtained tangible benefit from those assets, or that's a very powerful matter in the exercise of the discretion. Moving on from there to the position of Ms. Chen, it's undisputed in this case that Ms. Chen was not the person preferred. That was Zinato, and she was not the recipient of any or any part of the repayments to Zinato. Now, if we're right that section 249 is a restitutionary, not a compensatory provision, given she wasn't preferred, she wasn't a recipient of the payments, we submit that a discretionary order could only be made against her on the basis identified in Oxford Pharmaceuticals, as I said, that she personally benefited in monetary terms from the payment in some direct and tangible way. And that gives rise to two separate issues. The first one is whether personal benefit was pleaded. Now, the judge said in paragraph 14 of the trial judgment at page 23 that it's not pleaded that Ms. Chen derived any, and I mean any benefits from the repayments to Zinato, or that she had any motive for making the payment. And the Court of Appeal was expressly aware of the appellant's suggestion that it was expressly pleaded that she received a benefit. And that's paragraph 109, page 76. But when one looks at the three relevant parts of the pleading, the amended statement of claim, it's simply wrong to suggest that it's pleaded that Ms. Chen derived a reputational benefit. I'll give the committee the references. It's paragraph 38(1)(b) at page 125, where it says the reason for the repayment of the Zinato loan was Ms. Chen was concerned her personal reputation might suffer. Paragraph 38(5) on page 125, where it says it may be inferred that in making and or procuring the repayment of the Zinato loan, Ms. Chen was only concerned with or primarily concerned with her own interests and or the interests of Zinato. And then 41(2), which is at pages 126 to 127, where it simply says in making, causing or procuring PFF to repay the Zinato loan, she acted in her own self-interest or gave priority to her own interest by reference to her own reputation. So when one looks at those three paragraphs in the amended statement of claim, none of them amounts to an express or implied pleading that Ms. Chen received any benefit from the payments to Zinato. We submit there's a wide distinction both in fact and in law between the reason for causing or procuring a payment on the one hand and receipt of some benefit by reason of the payment having been made on the other. And the liquidators only alleged the former, they did not allege the latter. We submit there's no way an allegation of receipt of benefit can be spelled out of the language of the pleading. Second point is whether reputational benefit is sufficient under section 249. Now, the committee's already got my submissions that the benefit will only justify an order under section 249 if it's monetary or tangible. There are sound reasons for that, because unquantifiable and intangible benefits aren't capable of being returned or restored in a commercial sense, so they can't play any part in a restitutionary claim. And as I submitted before, to measure the benefit by reference to the company's loss would be another way of turning Section 249 into a compensatory provision. But a reputational benefit we submit is simply not capable of being quantified or returned or restored. So what we say is that a reputational benefit simply would not have been sufficient for the purposes of exercising the discretion against Ms. Chen under Section 249. So one then comes to the approach of the Court of Appeal. My learned friend briefly took the committee to do that a few minutes ago. And in Section 110 to 111, it rejected the contention that it wasn't permissible in law to make an order against Ms. Chen. Sorry, this is page 76 to 77 of the bundle. But it held the court could only exercise its discretion if the order was required as part of the process of restoring the position of the company to what it otherwise would have been. And we have submitted to the committee that it's both sides who have to be looked at, not just one side. And in paragraph 111, they said that absence of benefit doesn't necessarily include an order, but it is a factor which the court can take into account. And you were taken at page 77 to the to paragraphs 111 and 112 of the bundle, where the Court of Appeal deals with this. We, in paragraph 56, page 2270 of the bundle, we set out in our written case the reasons why we say the Court of Appeal made the only reasonable decision in not making any orders against Ms. Chen in the circumstances which we identify. Now, I'm not going to take the committee back to that, it's in writing, but I do want to remind the committee that we have set that out. But the appellants say that they give a number of reasons why it is that they say that the Court of Appeal got it wrong. And they say that the Court of Appeal failed to take account of the fact that Ms. Chen owed fiduciary duties to the company. Now, whether or not she did is a question of grounds 1 or 2, but even if the committee is against us on grounds 1 or 2, that doesn't assist the appellants, because whether or not Ms. Chen acted in breach of fiduciary duty would only be relevant to compensatory claims. It wouldn't be relevant to a purely restitutionary claim. And indeed, that is the conclusion reached by the learned judge in Johnson and Arden at paragraph 101 on page 2799 that I asked the committee to look at. And the learned judge there, deputy judge, came to the conclusion that there's no power to make an order under the English section 239 against the director who's received no benefit and whose only role is to direct the company to give the preference. Second point that the appellants raise is that the Court of Appeal wrongly concluded that and failed to take account of the fact that Ms. Chen was ultimately responsible for the making of the payments. Now, again, that would depend on a successful ground 3 appeal. But again, what we would say is that that assumes that whether Ms. Chen was ultimately responsible is a relevant factor under section 2491B. And since it's a restitutionary, not a compensatory provision, we say not. And again, we rely on Johnson and Arden, paragraph 101. The next point made in the appellant's written case of paragraph 100 is that the Court of Appeal was wrong to conclude that the court could exercise its discretion against a party if the order was required as part of the process of restoring the position, and that no orders were required against Ms. Chen for restoring the position. One has to look first of all at the word required, and in paragraph 100B of the appellant's case, they say there's no prospect of being able to recover the assets from Zinato for the reasons they give in paragraph 11 of their case, and neither the judge or the Court of Appeal made any finding that there was any such prospect. And with respect, that statement is inaccurate. There was no pleading and no evidence. There was no prospect of recovery from Zinato. During cross-examination, Mr. Byers said, and I'll give the committee the reference, it's page 1196, line 9 to 1197, line 2. Mr. Byers said that Zinato wasn't sued because the liquidators believed there was very slight likelihood of being able to enforce a judgment against Zinato's assets in the PRC. And I would ask the committee to look at the trial judge's reaction to that from page 1740, line 20 to 1742, line 12. But given that there was no pleading or evidence on the point, it's not surprising there was no finding by the judge or the Court of Appeal as to whether there's any prospect of recovery from Zinato. The court wasn't asked to make a finding. The finding wasn't relevant to the liquidator's claim against Ms. Chen. And the question is, and it's relevant to this element of required, is why wasn't Zinato sued? And in particular, that point becomes important when one looks at Oxford, and when in Oxford, the learned judge said at paragraph 84, well, the natural person to make an order against is the person who received the money. And indeed, in that case, he made an order against the person who received the money. And this point is emphasized by the fact the liquidators had been in correspondence with Zinato. The reference is Mr. Byers' first witness statement, paragraph 53, subparagraph 4 at page 872. Cross-examination, pages 1179 to 1180. Indeed, there was correspondence with Zinato. There's liquidator's letter of 15th of March 2013 at page 797. So the liquidators can't rely on any absence of the finding that there's any prospect of recovery. It may have been inconvenient or difficult to sue Zinato, but the liquidators have wholly failed to prove that there's no prospect of recovery. And indeed, in paragraph 100C, I'm sorry, may I just finish this point, although I know we're hitting 1 o'clock.
We've hit 1 o'clock, but do proceed for the moment.
Thank you. I'll only be a couple of moments with this. In paragraph 100C, the liquidator said there's no prospect of recovery against Zinato, so therefore an order is required against Ms. Chen. But our point is that absent being able to demonstrate there was no prospect of recovery against Zinato, the liquidators can't say that an order is required against Ms. Chen. But they can't demonstrate there was no such prospect. They made a commercial decision not to pursue Zinato because they could easily have sued Zinato as well as Ms. Chen. And indeed, Mr. Byers admits in cross-examination, page 1196, line 11 to 1197, line 2, that it was a commercial decision. This wasn't a case of no prospect of recovery. And true, it would be more convenient to get an order against Ms. Chen, but that's not what the statute provides. It provides required. And having chosen to sue Ms. Chen alone, they have to bear the consequences of the difficulties in establishing a claim against her as third parties. But again, liquidator's position is wrong because it assumes that this provision, section 2491B, is compensatory, not restitutionary. And I've already dealt with that point, and I won't go back to it. We also submit that the argument wrongly focuses solely on the position of PFF, not the position overall. Liquidators' claim would create a new position. It wouldn't restore the previous one. And a restitutionary remedy has its roots in equity. We submit it wouldn't be equitable to favour any one-sided position without regard to the overall position. And finally,
well, I think we'll wind up there and we'll sit again at 2 o'clock. Thank you very much.